have been taken up from time to time to bring economic, political, and social justice, such as the Lok Adalats and Gram Nyayalayas and such other user-friendly courts, etc. So, yet the judiciary still remains as LSU institution for the poor and the needy. So, this is the entire judiciary system as part of our syllabus. So in today's class, we are going to discuss about the state government. So the state government also has its three branches, namely legislative, executive, and judiciary, as we discussed in previous class in the in case of union government or parliament. In that chapter also we are discussed about these three branches. So in that part of that only we have discussed the previous class about judiciary system. So yeah, here the second chapter of the part sixth of our Constitution of India explains about the executive, which consists of the governor, chief minister of the state, and council of ministers. And chapter 3 of the part 6 of same part of the Constitution details the composition, powers, and functions of the state legislature. So in today's class, we are going to discuss about these concepts. So the Constitution provides about these state legislature composition, powers, and functions. So in today's class, we are going to discuss about the uh, composition of state legislature and powers and functions of legislative assembly and council, and also the relationship between the legislative assembly and legislative council. So and also we are going to discuss about the importance of state legislature. So if we see the state legislature, which means as like union legislature, here we are having state legislature too. So in the state legislature, the a uniform pattern of government is prescribed in the states of India. So the constitution makes a distinction between the bigger and smaller states. So as part of our constitution of India, in the part 6th of the constitution, from the articles 168 to 212, deals with the organization, composition, duration, officers, procedures, privileges, powers, and so on the of the uh, details about the state legislature. So, state legislature occupies a prominent and central position in the political system of a state. So, there is no uniformity in the organization of state legislatures, mixed pattern of unicameralism and bicameralism. So, states having unicameral system in 22 states, the state legislature consists of the governor, legislative assembly, and also 6 states are having bicameral system. Bicameral system means, as we discussed, two houses in a legislature part. So one is legislative assembly and another one is legislative council. If we see, the 6 states are Andhra Pradesh, Telangana, Bihar, Karnataka, Maharashtra, Uttar Pradesh. Uh, Before the this Jammu Kashmir Reorganization Act 2019, Jammu Kashmir also having bicameral system. So after Jammu and Kashmir Legislative Council was abolished with this Jammu Kashmir Reorganization Act 2019. So if we see, Article 169 says that Parliament can abolish a legislative council where it already exists or create it. So, if the legislative assembly of concerned state passes a resolution by a special majority to the effect, they can create or they can abolish this legislative council. So, this act of parliament is not to deemed as an amendment of the constitution for the purpose of the article 368 and is passed like an ordinary bill of a legislation by simple majority. As we discussed, simple majority means two-thirds simple majority. Those who are present in the house at that time of this bill passing. So this is the legislative council. If we see the legislative assembly's composition, the legislative assembly consists of representatives of people directly elected by the people on the basis of universal adult franchise. So minimum and maximum strength of the state legislative assembly is 60 to 500 respectively. If we see Arunachal Pradesh, Sikkim, and Goa is having 30 members. In Mizoram, 40. Nagaland, 46. Some members of legislative assemblies in Sikkim and Nagaland are also elected indirectly. Some members. So the nominated member procedure also there in some states, like the governor nominates one member to the assembly in the category of Anglo-Indian community. So if you see the 126th constitutional amendment bill does away the provision of this nomination of Anglo-Indians to Lok Sabha and some state assembly, as we discussed in previous class. So the constitution provided for the reservation of seats for scheduled castes and scheduled tribes in the assembly of the each state on the basis of population ratio. So, and also if we see this abolition or this council and assembly, the procedure is as like same parliament. So if you see the seats and constituencies will decided by the Election Commission of India. So territorial constituencies for legislative assembly, the demarcation of constituencies is done in a such manner to the ratio between the population of each constituency and the number of seats allotted to it is the same throughout the state. So the constitution ensures that there is uniformity of representation between different constituencies in the state. So some cases readjustment after each census. So after each census, a readjustment is to be made in the total number of seats in the assembly of each state and the division of each state into territorial constituencies. So in this case, the parliament is empowered to determine the authority and the manner in which is to be made. Accordingly, Parliament has enacted Delimitation Commission Acts in 1962, 1952, 1972, and 2002 for this purpose. So if you see in previous Delimitation Commissions Acts, 87th Constitutional Amendment Act of 2003 provided for the delimitation of constituencies on the basis of 2001 census. So if you see the composition of state legislative council, strength of a state legislative council is minimum of 40 to maximum of 1/3 that of the legislative of assembly. As we discussed, the membership is for assembly 60 to maximum 500. So here for council 40 to maximum 1/3 of the legislative assembly. So this arrangement ensures the predominance of the directly elected house, that is assembly, in the legislative affairs of the state. So the constitution has fixed the maximum and minimum limits, but actual strength is fixed by the parliament. So of the total number of members of a legislative council is 1/3 members are elected by legislative assembly members and 1/3 members of elected from local bodies and 1/12 members elected by graduates of 3 years standing and residing in the state and 1/12 members elected by the teachers of 3 years standing and not lower in standard than secondary school, and one-sixth members of legislative councils are nominated by the governor, and five-sixths of the total number of members of a legislative council are indirectly elected, and one-sixth are nominated by the governor. So the scheme of composition of legislative council as laid down by the constitution is tentative and not final. So the parliament is authorized to modify or replace the same procedure. So if we see the duration of these legislative assembly and legislative council, normal term is 5 years from the date of first session for the legislative assembly. And the legislative council is a permanent body as like Rajya Sabha. So however, governor can dissolve it any time for the case of assembly. Here in legislative council, one-third members retire every 2 years, and vacancy is filled at beginning of third year. So some cases, some in case of emergency, the term can be extended by 1 year at a time, but not beyond a period of 6 months after emergency is revoked. For case of legislative council, term of each member is 6 years. A member can be re-elected or renominated any number of times. So if we see the membership qualifications, so the qualifications according to the constitution for the membership for the legislative assembly, he is must be a citizen of India, and also he has completed 25 years or above for legislative assembly. We have to remember that the age is different for the assemblies and councils, and also for parliament and Rajya Sabha. If we observe for parliament and assembly, the age is same for 25 years. For Rajya Sabha and legislative council, age limit is 30 years age. For governor and president of India, the age limit is 35 years. So we have to remember this. So, and also for 30 years and above for legislative council. So additional qualifications, if we see, a person is to be elected to the legislative council must be an elector for an assembly constituency in the concerned state, and to be qualified for the governor's nomination, he must be a resident in the concerned state. And also a person to be elected to the legislative assembly must be an elector for an assembly constituency in the concerned state. So, and also he must be a member of SC or ST if he wants to contest a seat reserved for them. However, a member of SC or ST can also contest a seat not reserved for them in case of general category. So if we see the disqualifications of state legislator under the provisions of the Constitution of India, a person holds an office of profit under Government of India or any other state government other than that of a minister at a center or any state or in office declared by a law of the state, except any exemption made by certain states, and also mentally unsound as declared by competent court, and discharged insolvent, and also not a Indian citizen or has voluntarily got the citizenship of a foreign state, or is under any acknowledgement of adherence or allegiance to the foreign nation, these provisions can disqualify the person. So some cases disqualification on the ground of defection also. Defection means a person shall be disqualified for being a member of either House of State Legislature if he is so disqualified on the ground of defection under the provisions of the 10th schedule, which explains about anti-defection law. So the question of disqualification under the 10th schedule is decided by the chairman or the speaker. In the case of legislative council, speaker. In the case of legislative assembly, council, chairman. In the case of assembly, speaker, and not by the governor. So we have to remember this. The Supreme Court in 1992 ruled that the decision of the chairman or speaker in this regard is subject to judicial review. So, if we see the concept of this anti-defection, the 10th schedule of the Constitution of India was inserted in the Constitution 1985 by the 52nd Constitutional Amendment Act. So, it lays down the process by which legislator may be disqualified on the grounds of defection by the presiding officer of a legislature based on a petition by any other member of the house. So the decision on question as a disqualification on ground of defection is referred to the chairman or the speaker of such house, and his decision is final. As we discussed, presiding officer's decision is final in this anti-defection. So the law applies to the both parliament and state assemblies. If we see oath or affirmation, according to Article 164, subclass 3, states that before a minister enters upon his office, the governor shall administer to him the oaths of office of secrecy according to the form set out by the third schedule. So salary and allowances are determined by the state legislature. So members of state legislature are entitled to receive such salaries and allowances as may from time to time, which is determined by the state legislature. So if we see, the salaries and allowances is different from each state. So some states are giving their members high salaries, some states are less. So if you see, the presiding officers of the state legislature, each house of the state legislature has its own presiding officer. For assembly, speaker and deputy speaker. For legislative council, chairperson and deputy chairman. So if we see, the speaker of legislative assembly, so we will call it as a lower house also, like Lok Sabha, speaker and deputy speaker are presiding officers of the legislative assembly. So the speaker is elected by the assembly itself from amongst its members, so remains in office during the life of the assembly. So if a speaker vacates, if in case of he ceases to be a member of the assembly, he resigns by writing to the deputy speaker, he is removed by the resolution passed by a majority of all the then members of the assembly. If you see the speaker's powers, the powers and duties of the speaker does not take part in the debate and usually does not vote except in case of tie. So he maintains order and decorum in the assembly for conducting its business and regulating its proceedings. And also, speaker can exercise a casting vote in the case of a tie. So when the problem or any resolution in case of voting, the same two parties got the same voting percentage. At that time, the speaker has right to cast his vote to solve that problem. So he may adjourn or suspend the sitting of the house if necessary quorum is not there, or to restore discipline. We have to remember this concept of quorum. Quorum means 10% of members in the house has to be there to conduct a session. So that will call it as quorum. So he may even suspend and expel members of the house for unruly behavior or those who are opposing to conduct that session. He decides the questions and disqualification of a member for the assembly and arising on the ground of defection under the provisions of the 10th schedule. And also he appoints the chairpersons of all the committees of the assembly and supervises their functioning. So, and also speaker is the chairman of business advisory committee, rules committee, general purpose committee. And also speaker is the final interpreter of the provisions of the Constitution of India, the rules of procedure and conduct of business of assembly, the legislative presidents with the assembly. And also, he decides whether a bill is a money bill or not, and his decision cannot be challenged in the court of law. As we discussed in the parliament chapter, the speaker has this power to decide a bill is whether it is money bill or not. So if you see the deputy speaker of legislative assembly, the deputy speaker is also elected by the members of the assembly itself from their members. He is elected after the election of the speaker has taken place. So the deputy speaker performs the duties of the speaker's office when it is vacant or absent from the sitting of assembly. In both the cases, he has all the powers of the speaker. So the speaker nominates from amongst the members of panel of chairmen, any one of them can preside over the assembly in the absence of the speaker or the deputy speaker. So the salaries and allowances of the speaker and deputy speaker of the assembly are fixed by the state legislature. They are charged on the consolidated fund of the state, and thus are not subject to the annual vote of the state legislature. If you see the chairman of legislative council, if we remember, the chairman of the Rajya Sabha is ex officio chairman, like vice president of India. Here, for the legislative council is different. Chairman and deputy chairman are presiding officer of this legislative council. The chairman is elected by the council itself from amongst its members. So there, in case of Rajya Sabha, that is different. So there is only deputy chairman elected by its members. The chairman is vice president of India. So the business of legislative council is conducted by the chairman. He presides over the meetings and maintains discipline and order in the house. As a presiding officer, chairman of legislative council, the powers and functions of the chairman in the council are similar to those of the speaker in the assembly. So the speaker has one special power which is not enjoyed by the chairman. The speaker decides whether a bill is money bill or not, and his decision is on this question is final. So if you see the sessions of the state legislature, the governor of state summons the two houses of the legislature, which has to meet at least twice a year. So from the session to session, maximum gap should not exceed 6 months. So as we discussed, quorum is important for conduct sessions in both assembly and council. Until the legislature of a state by law otherwise provides the quorum to constitute a meeting of a house of the legislature of a state shall be 10 members or 1/10 of total number of members of the house, whichever is greater. So we will simplify that 10% of total number of members of the house is called as quorum. So the presiding officer adjourns or suspends the meeting if there is a no quorum. So the legislative procedures and privileges of state legislatures. So in case of legislative assembly, ordinary bills will be there. The bill procedure is same like parliament, and for money bill also same like parliament. No money bill can be introduced without governor's recommendation. For parliament, prior consent by the president of India. So such a bill is government bill can be introduced only by a minister in this legislative assembly. It can be introduced only in the legislative assembly. And also the bill is, if passed, it goes to the legislative council. The council can only discuss it and make recommendation. It has to be written bill with or without recommendations. within the 14 days period. So the assembly may reject or accept such recommendations made by the legislative council. So the bill is then given to the governor for consent. Governor may give or withhold it or send it for president's consideration. Uh, President too may give or withhold assent. So, but neither governor nor president can return the bill for reconsideration. So, if you see the privileges of state legislature are some of special rights, immunities, and exemptions enjoyed by the houses of state legislature, their committees, and their members. So, if you see, it has right to publish its reports, debates, proceedings, and also the right to prohibit others from the publishing the same. It can exclude strangers from its proceedings. It can punish all the members as well as outsiders. It has the right to receive immediate information. The courts are prohibited to inquire into the proceedings of house of its committees. No person can be arrested and no legal process can be served within the presence of the house without the permission of the presiding officer. It can institute inquiries and order the attendance of witness and send for relevant papers and records. And also, if we see individual privileges, they cannot be arrested, not applicable in criminal cases during the session of the state legislature and 40 days before the beginning and 40 days after the end of the such session. They have freedom of speech in the state legislature. No member is liable to any proceedings in any court for anything said or any vote given by him in the state legislature or its committees. So they are exempted from jury service. They can refuse to give evidence and appear in as a witness in any case pending in a court when the state legislature is in session. So uh, so some advantages also there. If you see the powers and functions of these state legislature, the state legislature has its powers as like Lok Sabha. The Constitution of India provides for a legislature in each state and entrusts it with the responsibility to make laws for the state. However, the composition of state legislature can be different from different states, as we discussed. Uh, uh, some states are having unicameral, some states are having bicameral legislature. Presently, only 6 states, as we discussed, 6 states are having bicameral state legislatures. So, if you see powers and functions of a state legislature, each state legislature exercises law-making process, law-making powers over the subjects of the state list and the concurrent list. In case of state has a unicameral legislature, that is in case it has only state legislative assembly, all the powers are exercised by it. However, even in case it is a bicameral state legislature with the state legislative council, what we called it as Vidhana Parishad, as the upper house and state legislative assembly as the lower house. Almost all the powers are exercised by the latter. The legislative council plays only a secondary and mirror role. So if you see the powers of a state legislature, the one is legislative powers. The state legislature can make laws on the subjects of state list and concurrent list. It can enact any bill on any subject of state list, which becomes an act with the signatures of the governor. Normally, the governor acts as a nominal and constitutional head and as such follows the advice of the state chief minister and his council of minister. However, he can reserve some bills passed by the state legislature for the approval of the president of India. Further, in case of a law made by the state legislature and a concurrent subject comes into conflict with the union law on the same subject, the latter gets precedence over the former. In ordinary lawmaking, both houses, legislative assembly and legislative council, wherever there exist together, have co-equal powers. In practice, the legislative assembly dominates the law making work. Most of the non-money ordinary bills are introduced in the legislative assembly, and it plays a major role in their passing. So the legislative council acts only as a revising and delaying second chamber. So a bill passed by legislative assembly and rejected by a legislative assembly are not decided upon the latter within 3 months of the period. When repassed by the legislative assembly becomes an act after the expiry of 1 month from the date of on which it was sent to the legislative council a second time. So a bill first passed by the legislative council becomes an act only when it gets the approval of legislative assembly. So the legislative council can only delay the passing of an ordinary bill by a maximum of 4 months. In case the state legislature is a unicameral body, all the lawmaking powers are exercised by the legislative assembly only. It has the financial powers too. If you see, the state legislature has the power to levy taxes in respect of all subjects of the state list. It is the custodian of the finances of the state. And also, no revenue can be collected or tax can be levied or collected by the state government without the consent of the state legislature. So the budget and all other financial policies and programs of the state government become operational only after getting an approval from the state legislature. However, in case of emergencies declared under Article 352 and 356 and 360, the financial powers of the state become subordinate to the union government. When the state is under constitutional emergency, in case of Article 356 imposed in a state, the state legislature stands either suspended or dissolved. In this situation, the financial powers for the state are exercised by the union government during the emergency. When the state legislature is unicameral, all the financial powers are naturally exercised by the legislative assembly. However, even when it is a bicameral legislature, the real financial powers are in the hands of the legislative assembly. A money bill can be introduced only in the legislative assembly, and after passage, it goes to the legislative council. The latter can delay its passage only 14 days. In case it rejects or amends the bill, the decision of the legislative assembly is prevails. When the legislative council returns a financial bill to the legislative assembly with some amendments, it is the power of the legislative assembly to accept or reject those recommendations. So thus, in respect of financial powers, the real authority is in the hands of the legislative assembly only. If we see, the third power of the state legislature is power to control the executive. The control over the state council of ministers is exercised by the state legislative assembly. Little role has been assigned to the state legislative council. The state chief minister is the leader of the majority in the state legislative assembly. The state council of ministers is collectively responsible before the legislative assembly. So the latter can cause the fall of the ministry by passing a vote of no confidence or by rejecting a bill or policy or budget sponsored by the Council of Ministers. The state legislative council can exercise only a limited control over the ministry by putting questions and supplementary questions to the ministers. So if we see the other powers of state legislature, the state legislature, particularly its legislative assembly, exercises several other powers. The elected members of legislative assembly, MLAs, participate in the election of the president of India. They also elect representatives of the state in the Rajya Sabha. Certain constitutional amendments can be made by the union parliament only with the ratification by at least half of the state legislatures in case of some special amendments or special cases. So the state legislature considers the reports of the State Public Service Commission, State Auditor General, and others. It also acts as a forum for ventilation of the grievances of the people. So the state legislative assembly has the right to adopting the a resolution for the creation or abolition of the state legislative council, as we discussed in starting of the classes. So position of a state legislature is occupies the same position in the state as it's is the position of the parliament in the union. So there is, however, a difference of degree in their relative powers. Indian Unitarian federalism makes the union parliament more powerful than each state legislature. So further, there are several specific limitations on the powers of a legislature. Some limitations of the powers of state legislature, like prior consent of President of India for introduction of some bills. There are certain bills which can be introduced in the state legislature only with the prior consent of President of India, which means in case of emergency implementing in their state, at that time, the assembly has to approach consent of the President of India. And also reservation of bills by the governor for president's assent. So there are certain bills which, after having been passed by the state legislature, can be reserved by the governor for the consent of the president of India. Such bills become laws only after the president has given his assent. So some limitations that can be imposed by the Rajya Sabha to the union parliament gets the power to pass laws on the state list for 1 year. If the Rajya Sabha adopts a resolution supported by the two-thirds of majority of its members and declares a state subject mentioned in the resolution as a subject of national importance. So as we discussed, during the emergency period only, the center enters into the state list and concurrent list. So during national emergency, when a national emergency under Article 352 is in operation, the parliament is empowered to pass a law on any subject of state list. The law so passed operates during the period of emergency and for 6 months after the end of the emergency. So in case of constitutional emergency, according to Article 356, the Union Parliament gets the authority of making laws for the state. So the state legislature stands either dissolved or suspended. So some discretionary powers of the governor will be there in this state legislature. The discretionary powers of governor of a state also constitute a limitation on the state legislature. Whenever he acts in his discretion, he is beyond the jurisdiction of the state legislature. Acting in his discretion, the governor can even dissolve the state legislative assembly. So in some cases, the state legislature and the union parliament both have the concurrent power to make laws on the subject of concurrent list. If the both union government and the state legislature pass a bill on the same subject of this concurrent list, and there is inconsistency between the two, the law passed by the union government or union parliament gets precedence over the corresponding state law. So ultimate power goes to the union parliament. So Thus, each state legislature in India exercises lawmaking powers over the subjects given to it by the Constitution of India. However, even in respect of this, it exercises lawmaking powers under the above constitutional limitations. Nevertheless, is general. The state legislatures act as important and powerful legislature in all the states and union territories in India. So, if you see, each state legislature exercises lawmaking process over the subjects in the state list. In case of unicameral legislature is there. So, if we see comparison between the union territories and states, only Delhi, Pondicherry, and Jammu Kashmir having legislative assembly and council of ministers headed by therefore the administrators of the three union territories are meant to act upon the aid and advice of the chief minister and his council of ministers. So so this is the normal powers of this state legislature. So if we see the electoral functions of the state legislature, only the elected members of the Vidhana Sabha legislative assembly are entitled to participate in the election of the president of India. The as we discussed for the president of India, only elected members of the parliament and assembly will be participate in this electoral process. So in that case, these elected members of legislative assembly are the part of electoral college for the election of the president of India. So the members of the legislative assembly do so in their capacity as the members of electoral college. So, but the members of the legislative council are not entitled to vote in the election of the president. Members of the Rajya Sabha from each state are elected by only the members of assembly and not of the council. So, these many states prefer to have unicameral legislature, but the legislative council is not superfluous. So it serves as a check on has the legislation made by the legislative assembly by highlighting the short bills comings or defects of the bill. So it lessens the burden of the legislative assembly as some bill are initiated in the legislative council. So as we discussed, the state legislature consists of governor, legislative council, legislative assembly. In most of the states, there are unicameral legislatures. So, if you see these powers of state legislature, all the powers are same like union legislature. So, if you see articles from article 166 to 177, all are discussed about the state legislature. So so this state legislative assembly of any state possesses exclusive power to formulate laws in respect of any matters in the list 2, which called it as state list. So in reality, the decision of the center or union government is considered to be superior, where the control by the central government is considered to be expedient in the public interest by the Parliament of India. So, if we see the bicameral state and unicameral state system, so unicameral legislature is one which just only one legislature chamber perform all functions. In case of bicameral, legislative council will be there but in the fast track process, most of the countries have unicameral legislatures. So it is the most common. It is an effective kind of legislation, since it makes the lawmaking process easier and decreases the probability of obstacles. In case of bicameral state system, only 7 states in India have a bicameral legislature. A bicameral legislature, on their other hand, may not be an effective as a unicameral legislature. So in certain circumstances, though it acts as a stumbling block, since it makes the legislative process more complicated. So abolition of creation of legislative councils. The legislative council is the upper chamber of a bicameral legislative in our country. So Article 169 of the Indian Constitution provides of its establishment, and it can also be removed under the same provision. So the legislative council is created and abolished under the Article 169. So if we see the relationship between the legislative assembly and council, the state legislature consists of state legislative assembly and council. So the assembly can initiate a bill and send it for the approval of the council. The council can retain ordinary bill for 4 months, and they should send reply. So in case money bills, the state assembly send the proposal to the council, but council has to be written within the period of 14 days of its referral or its consent. So if the legislative council fails to send back the money bill within 14 days, the bill is deemed as approved by the legislative council. So again, both houses of state legislature functions harmoniously with mutual cooperation. If the same political party enjoys majority in both houses, there are also instances of conflict between these two houses. So this is the state legislature. If you see the advantages of these uh, legislative councils, uh, a second house can help check hasty actions by a directly elected house, so, and also enable non-elected individuals to contribute to the legislative process. So it provides a forum for academicians and intellectuals who are arguably not suited for those rough and tumble of electoral politics. And also it provides a mechanism for more sober and considered appraisal of legislation that a state may pass. Other arguments cited in favor of legislative councils range from their track record of sincere work, relevant amendments brought, non-confrontational attitudes vis-a-vis legislative assembly, decorum, and restraint it in proceedings, and drawing attention of both government and public to the matters of public interest. Some disadvantages also there with this legislative council. A legislative council can be used to delay legislation process. The forum is likely to be used to accommodate party functionaries who fails to get elected. It can also be an unnecessary drain on the exchequer. Moreover, graduates are no longer a rarity, also with dipping educational standards and graduate degrees, no guarantee of any real intellectual felt. So these are the advantages and disadvantages of legislative council. If we see, there is special provisions for Delhi. The 69th Constitutional Amendment Act of 1991 provided a special status to the Union Territory of Delhi. So it is redesignated it as the National Capital Territory of Delhi and designated as the administrator of Delhi as the Lieutenant Governor. So it created a legislative assembly and legislative council. So Council of Ministers. So the strength of assembly fixed at 70 members directly elected by the people. The elections are conducted by the Election Commission of India. The strength of the Council of Ministers fixed at 10% of total strength of the assembly. That is 7. So comparison between the Delhi and state, the chief minister is appointed by the president, not by the lieutenant governor. The other ministers are appointed by the president on the advice of the chief minister. In case of state, the ministers holds office and chief minister appointed by the state's governor, lieutenant governor in case of union territory. So in case of difference of opinion between lieutenant governor and ministers, lieutenant governor needs to refer the matter to the president for decision and act. So only Delhi and Pondicherry, Jammu Kashmir Union territories having these legislative assemblies. So this is our state legislature chapter. So in tomorrow's lesson, we are going to discuss about chief minister and governor. So tomorrow is our last online class. In tomorrow's class, we are going to discuss about governor, chief minister, and the council of ministers. Is there any doubts from the today's lesson? Okay, thank you for your participation. Is there any doubts? Pavitra, yes, ask.
జార్ఖండ్ అండ్ మధ్యప్రదేశ్ ఒరిస్సా నుంచి ఓన్లీ ట్రైబల్ మినిస్టర్స్ కావాలా లేకపోతే అదర్ కాస్ట్ వాళ్ళు కూడా అవ్వచ్చు?
అట్లా ఏముండదు. Anyone can be eligible. The final decision is chief minister's hands. The rule of reservation is there, na? As per the rule of reservation, the ministers are elected according to the that procedure. So any caste aina evaraina elect kavachu. Okay, thank you for your participation. I am concluding the session. Tomorrow, same time, 10:30, we will meet again. Thank you.